For smaller businesses or smaller individuals, or maybe for the investor client, another case has come along, which again is making waves, about a long-standing tax relief, which historically has generally only been thought to be available in particular circumstances. We've long had in the UK a relief intended to facilitate the transfer of businesses from unincorporated status to limited company status, incorporation relief under Section 162 of the 1992 Capital Gains Tax Act, a relief which acts to defer capital gains behind the cost of the shares when one incorporates a business wholly in exchange for shares. The business is transferred to the company in exchange for an issue of shares for the assets transferred to the business. But what sort of business is eligible for this particular relief? Historically, generally it's been the case that only trading businesses have been able to use this particular relief. Indeed, historically, the view of HMRC has been that this relief is restricted mainly, principally, to trading businesses. But the phrase in the legislation is the incorporation of a business, not the incorporation of a trading business. Along comes the Elizabeth Moyne Ramsay case, where a couple transferred a portfolio of rental properties to a limited company and claimed the benefit of Section 162 relief. The Revenue refused the relief, saying it wasn't available for investment businesses, and so the case came before the tribunals in order to try and decide whether this particular relief was available in those circumstances. And, much to the surprise of many advisors, I would say, the relief has, at the moment, been granted. Again, an appeal is likely. But the judgment seems fairly robust. The point was made that, in this case, the property rental business that the couple were carrying on did involve a lot of active servicing and management of the portfolio of properties. A lot of services were apparently offered with the rental of the properties. And the business was carried on very much on a commercial basis. It was clearly carried on with a view to profit. It was clearly not meant to be just a passively managed investment activity. At least that seems to have been the view of the court. The Revenue clearly doesn't think that that is sufficient to facilitate the available of the Section 162 relief. And certainly many commentators have been rather surprised that the relief has been granted at the moment in this case. Historically, I would rarely have considered that a portfolio of rental properties, a passive investment activity, basically, could be eligible for this relief. But modern trends are for property owners, property business managers to offer a lot more servicing of their properties. One sees the development in large cities, for example, of different types of short-term rental activity, overnight rental of flats and things, or weekly or monthly rentals of flats for short-term occupiers. There are businesses which concentrate on offering, almost on an agency basis, access to people's flats who are perhaps working away as expatriates overseas, almost on a hotel basis. One gets the keys, one uses somebody else's flat, maybe on a 3 or 4 night basis, or weekly, or a couple of weekly basis. What is that? Is that property rental? Is it managed property activity? Is it a quasi-hotel activity? There are even properties being developed on a quasi sort of hotel basis, but they are sort of self-catering, almost self-managed. Access to the property is basically just on a key basis for a nightly or a weekly fee. Perhaps it's the case that legislation hasn't kept pace with these modern developments in these new sorts of property rental activities. For the traditional property rental business, however, the availability of this relief, the ability perhaps to transfer a portfolio of properties into a company in order to take advantage of the 20% rate of corporation tax, which obviously for some investors is considerably lower than their 40 or perhaps even 45% rate of personal income tax. It's a very attractive proposition indeed. So one can see why property investors would want to take advantage of incorporation relief. It remains to be seen where the case goes, but certainly the Moyne Ramsay case has come as something of a surprise to many people, me included, who have traditionally taken the view that where the bulk of the activity contained within a business was property rental, which has always traditionally been granted less favourable tax status, i.e. regarded as a passive investment activity. This is quite an interesting development, and one, again, to keep an eye on.